well, can I leave Kazi behind against the background of what I've already said about it? As is well known, in the intervening period between Kazi and Kay, there were two decisions of the Strasbourg court which effectively paused the examination in Kay. The first of them is Connors, and the second is Bleckich, if I pronounce that correctly. Connors is to be found at volume 12, tab 105. Possible to take the facts from the head note, and so at page 189, the very first page of tab 105, the head note recites that the applicant and his family are gypsies who led a traditional travelling lifestyle until they suffered so much from harassment and being moved on that they settled on a local authority gypsy site at Cottingley Springs. Lived there permanently for about 13 years until February 1997 when they moved on, complaining about the antisocial behaviour of others living on the site. Moved into a rented house but were unable to adapt. In October 1998 they returned to Cottingley Springs and were licensed to occupy a plot at the site provided they did not cause a nuisance. In March 1999 the applicant's adult daughter was granted a licence to occupy the adjacent plot where she lived with a man who later became her husband. He was a member of the family against whom proceedings had been brought for eviction from the site on the grounds that they were a magnet for trouble. The applicant's adult sons were frequent visitors to the site. On January 31st, 2000, notice to quit was served on the family, requiring them to vacate both plots. No written or detailed reasons were provided by the council, where the issue of magnet for troublemakers had been raised. In March 2000, the council issued proceedings for summary possession. The site manager asserted the defendants had breached the licence agreement. The applicants disputed the allegation. At this stage, he and his wife lived with their 4 children aged 14 years, 13 years, 10 years and 4 months. One of the children had kidney problems, and the applicant's wife, who was asthmatic, had suffered several attacks during visits to hospital. The applicant himself had been having chest pains and was awaiting a hospital appointment. The 10-year-old child had settled into full-time education at the local primary school, and other children were receiving assistance, including teaching at home. Early on August 1st, 2000, the council evicted the family in an operation lasting 5 hours. Their 2 caravans, one owned, the other rented, were removed. The applicant claimed that the one they owned was not returned until late that afternoon. Then 2 days later, the council returned their possessions dumped on the roadside some way from the caravan. The applicant alleged the family received no assistance or advice as to where they could go, except for an offer of accommodation which failed to take into account their local ties. He stated that during the eviction they'd been required to move on repeatedly, and that the stress and uncertainty had contributed to his wife's decision to move into a house with younger children. And he and his wife separated in May 2001, and following the eviction, the 10-year-old child had not returned to school. So that's the background.
Yes, the right to terminate the licence was at will, was it? There was no need to have any good reason.
That's absolutely right. And we'll see in a moment that that was in contrast to the statutory scheme which regulated occupation of other types of caravan sites. That's the crucial background. But I read the facts because when we come to Lord Brown's speech in Kay, I do rely on the fact that Lord Brown thought that some form of judicial review challenge might have been got off the ground on the sort of facts of Connors. So, and I will convert that into an argument to the effect that Connors is plainly an example where, quite apart from the deficiencies in the statutory framework, which the Strasbourg court thought existed, a proportionality argument would not only get off the ground but might well succeed now in the county court, given the later domestic case law developments. The court states its general approach to the case, to the principles in play in the case, paragraphs 81 through to 84. The court say interference will be considered necessary in a democratic society for a legitimate aim if it pursues a pressing social need, and in particular, if it is proportionate to the legitimate aim pursued. While it is for the national authorities to make the initial assessment of necessity, the final evaluation as to whether the reasons cited for the interference are relevant and sufficient remains subject to review by the court for conformity with the requirements of the Convention. In this regard, a margin of appreciation must inevitably be left to the national authorities, who by reason of their direct and continuous contact with the vital forces of their countries are in a principle better placed the international court to evaluate local needs and conditions. The margin will vary according to the nature of the convention right at issue, its importance for the individual, nature of the activities restricted, as well as the nature of the aim pursued by the restricted. And then, importantly, the margin will tend to be narrower where the right at stake is crucial to the individual's effective enjoyment of intimate or key rights. On the other hand, in spheres involving the application of social or economic policies, there is authority that the margin of appreciation is wide, as in the planning context the court has found that, and then there's a citation from Buckley showing a wide margin of appreciation in that sort of area. The court has also stated that in spheres such as housing, which play a central role in the welfare and economic policies of modern societies, it will respect the legislature's judgment as to what is in the general interest, unless that judgment is manifestly without reasonable foundation. It may be noted, however, that this was in the context of Article 1 of Protocol 1, not Article 8, which concerns rights of central importance to the individual's identity, self-determination, physical and moral integrity, maintenance of relationships with others, and a settled and secure place in the community. Where general social and economic policy considerations have arisen in the context of Article 8 itself, the scope of the margin of appreciation depends on the context of the case, with particular significance attaching to the extent of the intrusion into the personal sphere of the applicant. The procedural safeguards available to the individual will be especially material in determining whether the respondent state has, when fixing the regulatory framework, remained within its margin of appreciation. In particular, the court must examine whether the decision-making process leading to the measures of interference was fair and was such as to afford due respect to the interest guarded by the individual by Article 8. The vulnerable position of gypsies as a minority means that some special consideration should be given to their needs and a different lifestyle, both in the relevant regulatory framework and in reaching decisions in particular cases. To this extent, there is thus a positive obligation imposed by the contracting states on the contracting states by virtue of Article 8 to guarantee the gypsy way of life. And then the court goes on to apply those principles in the present case. And I can pick it up in about 10 lines into paragraph 85. The court says the applicant contested that he was at fault. It is not for the court, however, to assess in retrospect whose version of events was correct, as the counsel in evicting the applicant relied instead on the power to give 28 days' notice to obtain summary possession without proving any breach of licence. It's various alleged by council officers that the applicant's licence conditions had been breached due to the unruly conduct of persons on his pitch, and contended by the applicant that any problems arose from adult visitors from off the site over which he had no control. The respective merits of the arguments were not examined by the county court proceedings, which were only concerned with the fulfilment of the formal conditions for the eviction. The central issue in this case is therefore whether, in the circumstances, the legal framework applicable to the occupation of pitches on local authority gypsy sites provided the applicant with sufficient procedural protection of his rights. And then over the page, the serious interference with the applicant's rights under Article 8 requires, in the court's opinion, particularly weighty reasons of public interest to be afforded to the national weighty interest by way of justification, and the margin of appreciation to be afforded to the national authorities must be regarded as correspondingly narrowed. The court would also observe that this case is not concerned with matters of general planning or economic policy, with a much narrower issue of the policy of procedural protection for a particular category of persons. The present case may also be distinguished from the Chapman case, in which there was a wide margin of appreciation, as in that case it was undisputed that the applicant had breached planning law in taking up occupation of land within the Greenbelt in her caravans, and claimed in effect special exemption from the rules applying to everyone else. In the present case, the applicant was lawfully on the site and claims that the procedural guarantees available to other mobile home sites, including privately run gypsy sites, to local authority housing, should equally apply to the occupation of that site by himself and his family. And then the court records in paragraphs 87 through to 90 the government's justification for the particular scheme, which was effectively to say that the management issues that arose with gypsies justified a regime with no security, effectively, for the occupation of caravan sites by gypsies. And then in 91, the court records that the domestic courts have examined this regime in cases which they've cited earlier in the report and not found a breach. And then the core of the final reasoning is paragraphs 92 through to 94. Paragraph 92. The existence of other procedural safeguards is, however, a crucial consideration in this court's assessment of the proportionality of the interference. The government has relied on the possibility for the applicant to apply for judicial review and obtain scrutiny by the courts of the lawfulness and reasonableness of the Council's decisions. It will be possible to challenge the Council for any failure to take into account in its decision-making relevant matters such as duties towards children. The court would recall that the applicant sought permission to apply for judicial review and that permission was refused. In the applicant's case, his principal objection was not based on any lack of compliance by the council with its duties or any failure to act lawfully, but on the fact that he and the members of the family living with him on the plot were not responsible for any nuisance and could not be held responsible for the nuisance caused by others who visited the site. Whether or not he would have succeeded in that argument, a factual dispute clearly existed between the parties. Nonetheless, the local authority was not required to establish any substantive justification for evicting him, and on this point judicial review could not provide any opportunity for an examination of the facts in dispute between the parties. Indeed, the government drew the court's attention to the Court of Appeal's decision in Smart, where it was held that to entitle people housed under homelessness provisions without security of tenure to have a court decide on the facts of their cases as to the proportionality of their evictions would convert their occupation into a form of secure tenure and in effect undermine the statutory scheme. While therefore the existence of judicial review may provide a valuable safeguard against abuse or oppressive conduct by local authorities in some areas, the court does not consider that it can be regarded as assisting the applicant or other gypsies in circumstances where the local authority terminates licences in accordance with the applicable law. The court would not underestimate the difficulties of the task facing the authorities in finding workable accommodation solutions for the gypsy and traveller population, and accepts that this is an area in which national authorities enjoy a margin of appreciation. And then there's a reference to the complexity of the situation having been enlarged because some gypsies have ceased to be nomadic. And then 94, however, even allowing for the margin of appreciation which is to be afforded to the state in such circumstances, the court is not persuaded that the necessity of a statutory scheme which permitted the summary eviction of his applicant and his family has been sufficiently demonstrated by the government. The power to evict without the burden of giving reasons liable to be examined as to their merits by an independent tribunal has not been convincingly shown to respond to any specific goal or to provide any specific benefit to members of the gypsy community. References to flexibility and administrative burden have not been supported by any concrete indications of the difficulties that the regime is thereby intended to avoid. It would therefore appear that the situation in England as it has developed would rather appear that the situation in England as it has developed, for which the gypsies must take, which the authorities must take some responsibility, places considerable obstacles in the way of gypsies pursuing an actively nomadic lifestyle, while at the same time excluding from procedural protection those who decide to take up a more settled lifestyle. So, while pausing there is no doubt that a significant holding by the European Court was that the statutory scheme was defective because it failed to provide any protection, any procedural protection for the position of people in the same position as Mr. Connors. But it's also clear that the European Court considered that the factual material that would be available to Mr. Connors might well found a successful argument that any eviction was itself a breach of Article 8. And as we will see later, that is very much the line that's taken by Strasbourg, later Strasbourg cases such as McCann.
What did you get out of this, apart from the 6 propositions in your paragraph 18?
Paragraph what? 18.
Verse 6.
So it must be 18. 1-8. 1-8.
1/8 of my case, as I understand it.
I only asked because I myself would have preferred to have a signal before you read all of this as to what you're getting out of it. But I think you do get those 6 propositions.
Yes, we certainly do say that the combination of the line of authorities I'm now taking your lordship to, which is Connor Blakich, if that's the right way of pronouncing it, followed by McCann and the other cases that we referred to in paragraph 18, lead to these 6 propositions. They also lead to the conclusion that Kazi needed adjustment. That's not contentious because the Kazi laws accepted that in K. But it also leads, in our submission, to the contention that the division that K and Doherty maintained, between judicial review on conventional Wednesbury grounds is not compatible with the approach that Strasbourg has taken to proportionality, the Article 8.2 balancing exercise, and accordingly not compatible with the correct approach to what we say is the result required by Section 6.1 of the Human Rights Act.
Do we need to look at the points on Article 6 and Article 13? Because that's the developing saga as well, isn't it? The court found that there were not procedural safeguards, but that it wasn't an Article 13 situation.
Yes.
So that implicitly one would have thought that if there had been administrative safeguards, that would have sufficed. And one would have thought Article 13 was more likely to be in play than Article 6, and yet the court there said that there was no separate issue under Article 6, but specifically found that there was no violation of Article 13.
Yes, I'm just absorbing that. It plainly is a case for saying that the last sentence of paragraph 109 supports a reading of Connors, which says that it is concerned with the structure of national legislation and not with the individual rights of Mr. Connors. But the difficulty with that is that it's not sustainable in the light of the subsequent Strasbourg case law.
It's rather paradoxical. I think Mr. Stillitz argues that it is sustainable, indeed demonstrable in the light of subsequent Strasbourg case law. But anyway, am I right that you say in the light of this that in relation to Mr. Stilitz's argument that one isn't going to descend into examination of the reasons of the local authority for taking steps to recover possession or its underlying needs, that this contains statements which seem to contemplate precisely that.
Well, absolutely.
Paragraph 94, and also, I think, addressing Mr. Arden's constant reliance on the dictum of Lord Justice Laws in Smart in paragraph 92, this seems to be suggesting that that dictum may not stand, if I read it rightly. His concern, understandable, was that if you introduced a full proportionality protection, you'd effectively be converting non-secure tenancies into secure tenancies. And yet here they quote that passage, and they seem, although they don't state it very specifically, seem to be not following it or not approving it.
Absolutely.
Yes.
Yes, and I don't shy away from the proposition that recognising the existence of potential Article 8 defences adds a layer of protection, even in situations where Parliament has abstained from creating statutory protection.
Abstained is putting it a little bit weakly, is it not?
Decided not to.
Yes.
Yes, I'm perfectly
Or in
happy.
this case, positively introduced something that takes away what was previously there.
Yes. I'm perfectly happy to accept that alteration of the way in which I was putting it. But that does not mean that the introduction of an Article 8 defence means that in every case, someone who is not a secure tenant, to use that example by reason of a deliberate parliamentary decision, just to make it plain what I am saying, is thereby given the equivalent status under Article 8. It all depends on the strength of the proportionality argument that is available to the individual. And going back to the conversation that we were having before the short adjournment, as to what factors will feed into a proportionality argument. But it certainly doesn't mean that, take an extreme example, an individual who has been resident in local authority premises for, say, a year, perfectly lawfully, but under a non-secure tenancy, is on the termination of that tenancy in the same position as a secure tenant. One on my arguments would expect to find that the property rights of the landlord would triumph in that sort of situation. You need something powerful to feed into the proportionality argument. Now, the problem is whether one needs to formulate that and how one avoids it simply being an exceptionality test, which for all the reasons I was given before the short adjournment, we don't accept is the principled way forward.
Well, it's how you find a way of putting it differently from the reasonableness that operates in most of the statutory schemes which do allow the court flexibility, and avoiding exceptionality and somehow defining a proportionality set which comes between those two.
But if you just take reasonableness...
Take what?
Just take reasonableness, sorry, my Lord.
I don't mean Wednesday reasonableness, I mean the statutory requirement of reasonableness
I understand
that operates in
completely
this
what your
field.
ladyship's putting to me. The difference in my submission is this, that in a secure tenancy, the starting point for examination of reasonableness by the county court judge will be precisely that the tenant is a secure tenant. So however little time he or she has been there for, he or she will have been the benefit of an allocations procedure which gives him or her statutory protection. That's the starting point. So then you, the county court judge, say, are these rent arrears of sufficient quantum, are they sufficiently long-lasting to mean that despite the fact that you're the beneficiary of the allocations decision, it's reasonable to make the order. And no doubt one could carry out a similar analysis in any of the other discretionary grounds where you can only make an order that's reasonable to do so. Your starting point will be that the tenant does have statutory protection. In an Article 8 case, take the extreme example I gave a moment ago, the tenant who has been there in one of the situations that are adumbrated, I think, in Mr. Arden's case, where a local authority tenant is not a secure tenant. The starting point is precisely that they do not have security. And as I was saying before the short adjournment, the starting point, therefore, is that there is, on the face of it, an unqualified domestic right to possession. Therefore, you need something very substantial to place in the balance under Article 8. So, in our submission, it is simply, with respect, wrong to say that one converts the non-secure tenant into the secure tenant because there is a proportionality exercise that must be gone through. Because as far as I can, well, for the reasons I've given, the starting point in the two cases is different.
But you only have that starting point and a requirement of something very substantial to place in the balance if the lack of security is fundamentally fair. And as I read Connors, what they were saying is that it's fundamentally unfair. There's no real reason to discriminate against
yes.
travellers.
Absolutely.
And so on that basis, effectively, the court was saying they should have been more in the position of a secure tenant.
That I accept. Yeah. And by submission, one can carry over the same line of thinking to the joint tenancy examples, because it may well be that the Strasbourg court in McCann is effectively saying that the relationship between the common law rule that one tenant who has been, is one of the two tenants who have been recognised as entitled to statutory security, can serve the notice to quit, is itself unfair or capable of producing unfair results. So one way of looking at the joint tenancy case is there is a systemic problem. Because I think, as we say in our case, the relationship between perfectly intelligible property law rule that one joint tenant can get out of the property obligations that are owed by virtue of the tenancy if they're no longer in the premises, but the relationship between that and the husband's status as a secure tenant is one in which the service of the notice may produce unfair results.
Is the last sentence of paragraph 85 the key to Connors?
Paragraph 85.
Paragraph 85. They say the central issue is, and they're looking at the legal framework, which in Connors' case was plainly defective.
Yes.
But the word legal framework, you would say, I imagine, embraces not just what the statute provides, but the way in which the court deals with the issues.
Indeed.
Is that right?
Yes. Yeah, so I certainly would say that.
So in this case, if we're looking at the structure you showed us this morning, we have a fairly detailed legal framework, but you've got to look at it through the eyes of what is needed in order to test reasonableness and proportionality at the final stage.
Yes. I mean, one of the problems about this case is that, in a way, the Connors style problem, to repeat myself, doesn't arise because the very careful structure of the demotion proceedings is obviously convention compatible, provided that the individual decisions of both the local authority, the court on making the demotion order in the first place, and then the review panel, are constrained by Section 6, as I say they self-evidently are. If one has that, then there is no structural problem with the demoted tenancy regime. It operates to protect convention rights precisely because the decision of the review panel is reviewable either by the county court or judicial review, which is an issue we're going to come to, on the basis that a disproportionate decision will breach Section 6.1.
So one's then taken to paragraph 94, and I think it's the second sentence. Would that be right?
Yes.
That's a crucial point.
Structurally, that's correct. The court was undoubtedly considering in Connors the compatibility of the statutory scheme with the Convention and holding that it was not compatible. But in my submission, it must also follow from that that if you have an individual case in which there is not statutory protection, the sort of factual matters that Mr. Connors was able to play in aid would be relevant to a proportionality balance in the individual case, in the county court or the judicial review court, depending on where we get to on the forum argument, in relation to issues raised under Section 6.1 of the Human Rights Act.
Well, the second sentence of paragraph 94 does seem to take it for granted that there have to be factually sustainable reasons justifying the interference. So that backs up your point that this is not only about procedures,
Yes.
it's also about substance.
I completely agree with that.
But you could have,
Picked up by 95. Sorry, I beg your pardon. It was just that 95 reinforces what Lady Helen said, because that's where it's drawn to a point.
Take the situation as it was in relation to travellers before the law was altered, in other words, as it was in the time of Connors.
Yeah.
Where there is a fundamental flaw in the scheme, it's difficult to see how a domestic court could of course also could of course say the scheme is incompatible. It's difficult to see how the domestic court could cure it by introducing in some way a full merits review on a judicial review basis or with proportionality, because you would effectively be undermining the scheme. The incompatibility would probably be the root, wouldn't it?
Well, the key to, I was going to be showing your Lordship, my lady, in a moment, Lord Brown's speech in K. That analysis, right, to come to a different conclusion, the analysis your Lordship has just put to me ought not to stand in the way of my analysis, which is to say, right, you have a Connors scheme. You have a deficiency in the Connors in the statutory scheme because it does not protect Mr. Connors procedures. But the local housing authority, or the authority responsible for the gypsy site, is not obliged to seek possession or to seek possession in a form which denies the court the ability to judge the reasons. And so that
Yes,
the way...
but I think I get the point, because yes. I think I have expressed it.
Yeah, you have. Look, this is where the argument slips into 6.2b,
Yes.
Your Lordship understand. But that is our answer to Connors is only about structure. Certainly Connors is heavily concerned with structure. I wouldn't dream of denying that for a moment. But you have a deficient structure. That does not require the authority responsible for running the gypsy site, in fact, to serve a notice without there being appropriate grounds for doing so, or to serve one in circumstances where the service of the notice is disproportionate.
They have a choice.
They have a choice.
In how they give effect to the statutory scheme. Let's not get into Section 6 yet.
Well, I don't think I can avoid 6.2b. It's one of the planks of the argument against me. It certainly was in the in the Court of Appeal. But yes, I mean, without the gloss, without the construction of 6.2b adopted in particular in K, then I would, without hesitation, submit that when I do submit, that the manager of the caravan site, who can, as a matter of pure property law, serve a notice without any reason, is not obliged to serve a notice without any reason, or to serve one in circumstances where it's disproportionate to do so. And that's the way in which the structural arguments in Connors can be reconciled with the need to protect proportionality in the individual case.
In the case of a secure tenant, the proportionality come in as well?
Well, I accept that there's no need for it to come in separately, or at least it's unlikely to play any separate role, because the considerations that the county court will take into account in considering whether it's reasonable to make the order will be identical to those that are in play under 8.2. At least as far as I can see, they're likely to be, because the starting point is actually one more beneficial to the tenant, as we've just been exploring, i.e. you're dealing with a tenant who has been, in relation to whom it has been decided that it's appropriate he has statutory protection. That's the starting point. So if a county court judge decides against that background that it's reasonable to make an order, a separate requirement that he specifically write down a conclusion that is proportionate to make the order is in my submission, unnecessary.
If you have two tenants, one secured, one not,
Yes.
and otherwise their position is exactly the same, the proportionality test would produce a different, or might produce a different result in the two cases.
Yeah. I think that follows from the way in which I'm putting it.
Because the starting point is different.
The starting point is different. I am not denying the relevance of either the domestic statutory scheme or the private law rights of the public authority landlord. They're both highly relevant to deciding whether or not eviction is proportionate. But that doesn't mean that what's happening is something other than a proportionality test. That's the core of the case, the core of this part of the case. So, just to repeat, the statutory tenant against whom it's reasonable to make against whom it has to be reasonable to make an order, will have that position judged on the basis that he is indeed a secure tenant, and that's the starting point. One would expect something rather higher by way of justification to be necessary than where someone is not a secure tenant as a result of, let me accept it, a deliberate decision of Parliament in setting up the statutory framework. But that doesn't mean that there isn't a proportionality issue to be decided.
So you're saying in every case where the court's required can only make an order for possession if it's reasonable to do so, that will work perfectly well because the reasonableness exercise will effectively take into account Article 8. So
yes.
To come back on the point about Article 8 and reasonableness being the same, reasonableness includes Article 8, but Article 8 is smaller than reasonableness.
That, I think, is what I've just said, effectively, I think. It certainly is my submission, whether I manage to say it or not.
Of course, in some contexts, it can be greater, because it may be just slightly different. Forgive me, I can see a parallel here with care proceedings taking children into care. Now, obviously, under domestic legislation, you have to have a threshold of harm or likely harm, and then you have to ask yourself whether taking the child into care is going to be best for this child. That doesn't have any proportionality in it on the surface, but nevertheless, once the Human Rights Act came in, family lawyers also started asking themselves whether this very serious form of intervention was a proportionate response to the size of the problem that presented itself. Whether it added up to different answers might depend, but all I'm saying is that I can see that in that context, as in this context, they might be slightly different, greater or lesser.
When you have already have a domestic reasonableness requirement to take into account, and indeed you can't make the order unless it's reasonable, then your point is it's slightly different. That would encompass if Article 8 said you shouldn't, then it, by ex hypothesis wouldn't be reasonable to make an order.
Yes. While these matters have been put to me, I've been thinking again about that. I was asked this morning about, or at least I made a submission about whether proportionality was the same as reasonableness in the extended sense in judicial review. One way in which it is potentially different is that it requires the court, or potentially different to the concept of reasonableness before the Human Rights Act came into force, is that it requires the court to concentrate firmly on the relationship between the legitimate aim that is being pursued and the measure that is being taken to accomplish that legitimate aim. And one goes back to Lord Staines's speech in Daly, I'm doing the same again, Lord Staines's speech in Daly, where Wednesbury may not require you to actually take the least intrusive step, for example. Proportionality certainly does. Now, translate that across into a post-Human Rights Act approach to the concept of reasonableness in the county court in secure tenancies. Court has to decide whether it's reasonable to make an order. That would encompass, the tenant will be able to say it's not reasonable to make an order because you're taking a sledgehammer to crack a nut, and for that reason it's disproportionate, or even less than that. I mean, maybe putting the proportionality argument too difficult, too high a threshold for the tenant. But I think, whichever way you put it, you either get the same result from reasonableness, or certainly the county court judge, when he's deciding whether it's reasonable to make an order, will have to be open to an argument that this is too oppressive, given the nature of the breach that's being alleged against the tenant, which is a proportionality argument.
The one thing which emerges from that is that every day in the county court, possession actions are being heard and reasonableness is being deployed. We're presented with the spectre of a lot of new and intolerable and unmanageable disputes arising in the context of other tenancies, non-secure tenancies. Is it possible to put a number on either and just, how many issues, how many cases fall within each category? I think your argument would be that the issues wouldn't be greatly different, and so it might be interesting to know how much one's extending the problem.
I can't give a hard statistical answer, but Your Lordship, I think it's in Mr. Arden's case, it's certainly in some cases, not mine, has a list of the categories of local authority tenancies which are not subject to security. For example, land held pending redevelopment or whatever. Now, and it's no more than common sense, but my gut reaction to that list is that the number of truly secure tenancies will far exceed the number of tenancies where the landlord is a local authority, but where there is no security.
Yes, we're talking, of course, about not the number of tenancies, but the number of applications to terminate. It may be that one would be surprised. I just don't know.
Well, I don't know either, and I'm not going to say I do know. But I mean,
wouldn't it be helpful, since we are faced with a factual argument, if we're to give it any credence, haven't we got to consider it on the facts? Are there any statistics, in other words, that could be found?
I suspect that's for Mr. Stillitz, but it's certainly not an answer that I can readily give.
You would say, let justice be done, though the heavens fall, would you not?
Well, I certainly would if I had to. Yes, but I certainly would if despite my entering into this discussion, I do submit that the analysis is inescapable, whether or not the administrative burden is difficult to live with or not. I mean, the simple fact is a decision by a local authority to take possession proceedings or to demote a tenancy or whatever is an act of a public authority, and it must be proportionate. There may be ways of limiting the scope of there may be ways in which the nature of the argument is necessarily limited, I think is the way I would prefer to put it, because of the weight to be attached to the simple property right of the local authority. And take, for example, one case which one does meet from time to time. The local authority holds land pending redevelopment. The local authority wishes to redevelop, and accordingly serves a notice. One wouldn't expect any proportionality argument to look any further than do they in fact intend to redevelop? The moment they say that in summary form, that will be the end of the proportionality argument. If they're evicting,
you will remember that there are members of the court at this end of the room as well.
Yes, I've been aware of that.
I'm not sure that I really quite gathered your final submission.
No. The submission I was making was in relation to land held by a local authority pending redevelopment. We know from, I think, it's Mr. Varden's list, that such tenancies are not secure tenancies. Now, in my submission, it is very difficult to see how any proportionality argument that arose in relation to such land would add anything of any burden to a local authority who wished to seek possession, because they would simply say, we hold the land on this basis of this statutory power for future redevelopment. That's what we intend to do. That's the end of it. You're in occupation on that basis. And I suspect one could go down Mr. Varden's list and find a similar set of arguments that were available in relation to each of them. The joint tenancy example may be one of the more troublesome, because that is quite a common position that does create genuine difficulties.
Is there anything more that we get from Connors?
No, look,
Then really it
not
stops at
from my
that point,
point of
doesn't it?
view, no. The next decision is a case called Blakich, B-L-E-C-I-C, if I'm pronouncing that rightly, which your Lordship will find in this, and my Lady will find in the same volume at tab 102. And my Lady, reading the head note for the facts, the applicant held a specially protected tenancy on a publicly owned flat in Zadar. In July 1991, she went to stay with her daughter in Rome for the summer, leaving her furniture and belongings in the flat. By the end of August, the armed conflict in Dalmatia had escalated, and from mid-September, Zadar was exposed to constant shelling, and the supply of water and electricity was disrupted. In October 1991, the applicant's pension was stopped and she lost the right to medical insurance. The following month, her flat was broken into and occupied by a family. Having no means of subsistence and no medical insurance, and being in poor health, she decided to stay in Rome. She did not return to Zadar until May 1992. In February 1992, just before her return, the local authority brought an action against the applicant for termination of her tenancy on the ground that she had been absent from the flat for more than 6 months without justification. The court terminated the tenancy, finding that her reasons for non-use of the flat were unjustified. Although that judgment was quashed on appeal and the case remitted to the first instance court, the Supreme Court eventually ruled against the applicant, and the Constitutional Court held that her rights had not been violated. Relying upon Article 8 of the Convention and Article 1 of Protocol 1, the applicant complained that the termination of her tenancy had violated her rights to respect for her home and the peaceful enjoyment of her possessions, held unanimously that there had been no violation of Article 8. And then the head note summarises the judgment, and it's easier to go to the judgment for that. And Lordships the Court will see in paragraphs 57 and 58, at page 195 of the report, that in paragraph 57, the Court summarises the legislative policy behind the statute, saying the Court notes that according to the government, the specially protected tenancies were established on publicly owned flats in the former Yugoslavia in order to satisfy the housing needs of citizens. The policy governing these tenancies secured quite favourable terms for the tenants, while requiring them actually to live in those flats. Section 99(1) of the Housing Act was aimed at the prevention of any abuse of the tenancy right by allowing for its termination in cases where persons holding the right did not observe its purpose, in other words, did not occupy the flat granted to them. This has not been disputed by the applicant. The court considers that the legislation applied in the applicant's case pursued a legitimate aim, namely the satisfaction of the right of the housing needs of citizens, and it was thus intended to promote the economic well-being of the country and the protection of the rights of others. The court sees no right to assume that it pursued any other purpose. It's not in dispute that in pursuit of these aims, the Croatian legislature was entitled, by enacting Section 99, to prescribe the termination of specially protected tenancies held by individuals who no longer lived in the publicly owned flats allocated to them, and the subsequent redistribution of such flats to those in need. The only point in issue is whether, in applying the provisions in the applicant's case, the Croatian courts infringed her right to respect for her home in a disproportionate manner. Well, then going over the page, your Lordship will see in paragraph 63, the Strasbourg Court records the fact that both the Municipal Court and the Supreme Court had held that there had been no justified reason for the applicant not to return to Zadar. And second sentence, each of these courts reached this conclusion after having duly considered the factual and legal questions arising in the dispute and conducted a careful analysis of the arguments put forward by the applicant. The courts gave detailed reasons for their decisions. In particular, both courts took account of the applicant's age and health problems and were satisfied that her physical condition would have enabled her to travel. Furthermore, they took the view that the escalation of the armed conflict could not be seen as a justified reason for leaving Zadar, since it affected every citizen of the town equally. Their conclusion were in evident compliance with the previously established case law of the Supreme Court on this matter. So pausing there has in fact, on the facts of this case, been an examination by an independent court of the factual reasons for the applicant's departure from Zadar. And in the following paragraphs, the court goes on to decide whether or not those decisions are proportionate, having already decided that the legislation pursues a legitimate aim, see paragraphs 57 and 58.
Does it actually decide that? It seems to decide whether the decisions were within the judicial authority's margin of appreciation as to what might be proportionate. I.e., it's for the domestic authorities to reach a decision on proportionality, and apparently there's a margin of appreciation which they will be given.
Well, yes. One way of looking at this decision, which is a way I've been tempted from time to time to look at it, is that it decides that the legislation pursues a legitimate aim, see 57 and 58. It then decides, i.e. the requirement that you don't leave the premises for more than 6 months without good reason, I paraphrase, but that requirement pursues a legitimate aim. The court perfectly properly considers that requirement is met, see paragraph 63. One way of what one might have expected thereafter is the court to be examining whether or not the structure of the legislation was proportionate. But I quite agree that what they actually do in paragraph 65 is decide that the judicial authority's decision is proportionate.
Isn't paragraph 68 the most important one? If one's looking at this case through the eyes of Kazi, as seen in the House of Lords, one's looking for pointers that there was something wrong with Kazi, and 68 might be taken to be a guide that it was in need of some kind of refinement.
Yes.
I mean, as it points out, there's no explicit procedural requirement in Article 8, but the decision-making process must be up to the standard that they describe in that paragraph. And in 70, they say, well, in Bletch's case, that requirement was actually met.
Yes. In particular, in paragraph 69, there's an oral hearing.
Yes.
In which we know from paragraph 63, the court considered the factual detail concerning the applicant's age and health problems. The court was positively satisfied on that factual material that her physical condition would have enabled her to travel. And they go on to find that the escalation of the armed conflict could not be seen as a justified reason for leaving Sadar, since it affected every citizen of the town equally.
It doesn't sound a very intense review by the European Court. It might encourage you in your submission that it would only be exceptionally that a domestic court would be criticised.
Yes, one can't avoid the private feeling that this is something to do with the war-torn situation against which both the European Court and the domestic courts, in this case, were having to consider their position. But it's certainly it's an inescapable fact that the applicant did have the chance to put to the court factual material dealing with both her age, health problems and physical condition. And your Lordship will have seen from the second half of paragraph 65 that the court says, in the light of the foregoing, which has been a discussion about margin of appreciation, in the light of the foregoing, the court is satisfied that the contested decisions were based on reasons which were not only relevant but also sufficient for the purposes of paragraph 2 of Article 8. It cannot be argued that the Croatian court's decisions were arbitrary or unreasonable, or that the solution they reached in seeking a fair balance between the demands of the general interest of the community and the requirement of protecting the applicant's right to respect for her home was manifestly disproportionate to the legitimate aim pursued. The court considers that when terminating the applicant's specially protected tenancy, the national authorities acted within the margin of appreciation afforded to them in such situations. And then paragraph 67 is dealing with an alternative argument that was being advanced, which is that they could, instead of terminating the tenancy, simply allocate the flat temporarily to another person, and that's rejected. And then, as my Lord Hope has indicated, in paragraph 68, the court indicates that the decision process involved in the measures of interference must be fair and such as to ensure due respect for the interests protected by Article 8. So, my Lord, Lady, those are the two cases that fall in the interval.
Pausing there, what do you get out of this decision?
Right. Precisely what Hope indicates I get out of it, which is that going back to 68,
And is your submission that one takes from 68 that this is a requirement in all cases where a tenant's right to possession is to be terminated?
Yes. Yes, but one has to feed into that what are the likely elements of a proportionality argument. So I don't regard paragraph 68 as inconsistent with the possibility, indeed probability, that there will be circumstances, take my redevelopment example, where as a matter of pure domestic law, the landlord has an undoubted property right. The statutory framework has abstained from giving any protection to someone in that situation, although the 8.2 question arises, and although there must be a machinery for deciding the 8.2 question, there may not be any difficulty about the content of the argument in that type of example. That's perilously close to the answer that was given in K, to which we're going to come in a moment, except that we don't accept that if the answer is near automatic or nearly automatic. There will be recognisable cases where the proportionality balance has real content and has to be struck. We'll then move on to K. Which your Lordship, which the Court will find at volume 5 of the authority, find tab 44. There were, of course, two cases in K, and it's the facts of the first which require some attention, because the facts of the second, which was Price, were a case of a short trespass by gypsies on local authority owned land, and none of the court had any difficulty in holding that there was no prospect of getting an Article 8 defence off the ground in those circumstances. We just concentrate on the facts of the first K, because it's part of the case against me, is that as Lord Bingham accepted that there was nothing to remit to the County Court under Article 8 on the facts of K, that demonstrates that there will almost never be anything to remit under Article 8. So the facts of K are described in the headnote. In the first case, the local authority in 1979 informally made available to a housing trust some of its short-life housing, which was unsuitable for use as general housing stock. The housing trust made the housing habitable and used it to accommodate homeless people who would not otherwise have qualified for housing. The arrangement between the housing trust and the occupiers purported to be a licence, not a tenancy. In 1986, the local authority granted the housing trust a written licence to use the properties, terminable on 3 months' written notice, and in 1995, the licence was replaced by head leases granted to the housing trust in respect of each of the properties for a period of 10 years, terminable on 6 months' notice by either party. In 1999, the House of Lords held that the occupiers were secure tenants, not licensees, of the housing trust. In response to the decision, the local authority terminated the head leases in accordance with their terms and began possession proceedings in the County Court against the defendants on the ground that they occupied the properties as trespassers. In preliminary rulings, the judge held that the local authority was not bound by the secure tenancies granted by the housing trust, and he struck out their defences based on Article 8 of the Convention for the Protection of Human Rights and Fundamental Freedoms, that their right to respect for their homes is infringed by the local authority's claims for possession. The Court of Appeal affirmed the judge's decisions. My Lord, before we leave the facts, it's possibly sensible to pick up Baroness Hale's observations at paragraph 193. And which reveals important background facts. It's page 538. sorry, that would probably possibly sensible to have the whole paragraph. 193, each of the cases before it is a classic example in which a defence based upon Article 8 would have had no real prospect of success. In the Leeds case, it cannot plausibly be asserted that the respondents had established a home on the recreation ground. There is therefore no convention right to be interfered with. In the Lambeth cases, the occupiers had undoubtedly established homes in the dwellings, but they had done so on terms which made them vulnerable, like many subtenants, to the superior claims of the landowner. Lambeth aims to evict them were in accordance with the law and in pursuit of the legitimate aim of regaining control over this short-life housing stock. All the Bruton tenants were offered alternative accommodation. It would take a very different case from that pleaded to give their claims to remain in the particular dwellings occupied a real prospect of success. Now, with respect, I don't quarrel with that. In the sense, I do quarrel with the analysis that prevents the proportionality argument arising at all. But I recognise the fact that that paragraph is consistent with the fact that none of the minority whose opinions I say correctly take the correct legal approach would have remitted pay to the county court for decision. And a powerful reason for my acceptance of that position is that it is apparent that the recovery of possession was first of all a legitimate exercise of the local authority's housing management function. That is, they faced properties which had been available on a short-let basis, short-life basis, I should probably say. And secondly, that alternative accommodation had been offered. And accordingly, I respectfully accept that it would be difficult to actually succeed in an Article 8 claim which had to relate to the particular dwellings occupied rather than to the provision of any housing at all. But I do rely and urge this court to accept, given the subsequent Strasbourg case law, the approach of the minority, which in this case consisted of Lords Bingham, Nichols and Walker. And Lord Bingham's approach can be seen from paragraph 33 onwards, 33 through to 39. Page 493. At the end of paragraph 32, Lord Bingham has drawn attention to the margin of appreciation, in essence. And paragraph 33 says, the third of these principles has obvious relevance in a context such as giving rise to these appeals, for the general property law of England and Wales has developed over the centuries, reconciling the rights and interests, sometimes in harmony, sometimes conflicting, of owners, landlords and licensors on the one hand, and occupiers, tenants and licensees on the other. And then there's a reference to the very specific detail of the housing legislation. And leading to the conclusion towards the end of the paragraph, this of course means that security of tenure for A means a denial of accommodation for B. Recognition of a right for C to succeed to a tenancy means there is no tenancy for D. An extension of time granted to E defers the date when F can find somewhere to live. Our housing legislation strikes a balance between competing claims to which scarcity gives rise, taking account, no doubt imperfectly, but as well as may be, of the human, social and economic considerations involved. And it is, of course, to housing authorities such as the respondents that Parliament has entrusted the power of managing and allocating the local authority housing stock and the pitches on local authority gypsy sites. And then 34, under some statutory regimes, is where discretionary grounds are relied on to terminate a secure tenancy under the Housing Act 1985, the court may make an order for possession only where other conditions for making such an order being met. The court thinks it reasonable to do so. This enables the court to take account of all the circumstances which it judges to be relevant. If in any case covered by such a regime, the statutory conditions are satisfied, and the court does, on consideration of all the circumstances, think it reasonable to make a possession order, the court would in effect have undertaken the very assessment which Article 8.2 requires. In such a situation, Article 8.2 adds nothing of substance to the protection which the occupier already enjoys. Although that's the subject of the discussion we've been having already. I wouldn't put it quite like that, but this is the opinion approach. And paragraph 35, under some statutory regimes, the court may be required to make an order for possession if certain prescribed conditions are met and there is no overriding requirement that the court considers it reasonable or just to make such an order. The statutory scheme is nonetheless likely to satisfy the Article 8.2 requirement of proportionality if it is clear that the statutory scheme represents a democratic solution to the problems inherent in housing allocation. And then there's a reference to popular housing, McClellan, which I'll come back to in SMART. And Lord Bingham ends by saying, at the end of paragraph 35, where a statutory scheme covers the case of an occupier and conditions are prescribed for obtaining possession, and those conditions are met, will only be in highly exceptional circumstances that the occupier will gain additional protection from Article 8. 36. There are, of course, some cases, of which the present cases are examples, in which the relationship between the public authority owner or landlord and individual tenant or occupier is not governed by any statutory scheme. The possession may be sought on the expiry of the period for which the right to occupy was granted, or because the notice was required by domestic property law to bring that term to an end has been given, or because one or more of the conditions on which the right to occupy was granted has been broken. It cannot be said that the relationship between the parties in such cases is subject of a balance struck by Parliament. It is not unrealistic to regard the general law as striking such a balance. The public authority owner or landlord has, broadly speaking, a right to manage or control its property within bounds set by statute. The occupier acquires a right, but only a limited right to occupy. On due determination of that interest, a claim for possession must ordinarily succeed, since any indulgence of the occupier necessarily derogates from the property right of the public authority, whose rights are also entitled to respect. Therefore, not surprising that in P v. the United Kingdom and U v. the United Kingdom, the occupier's complaints were held to be inadmissible because the public authority's interference or assumed interference was held to be clearly justified. It would again require highly exceptional circumstances before Article 8 could avail the occupiers. The peculiar facts and circumstances of Connors could fairly be regarded as crossing that high threshold, given the positive obligation to which reference is made in paragraph 24. And then paragraph 37, rarely, if ever, could this test be satisfied where squatters occupy the land of a public authority that they do not, and unlike Connors, never have had any right to occupy, and where the public authority acts timorously to evict them. The public look to public authorities to preserve their land for public purposes and to bring unlawful occupation to an end, and the environmental hazards that it is likely to entail. And then the reference to rules requiring, providing for the summary removal of squatters, and an observation that McPhail must be relaxed, an observation with which other members of the court did not agree. And then paragraph 38, I do not think it possible or desirable to define what facts or circumstances might rank as highly exceptional. The practical experience of county court judges is likely to prove the surest guide, provided always that the stringency of the test is borne in mind. They are well used to exercising their judgment under statutory schemes and will recognise a highly exceptional case when they see it. I do not, however, consider the problems and afflictions of a personal nature should avail the occupier whether a public service is available to address and alleviate these problems, and if under the relevant social legislation the occupier is specifically disentitled from eligibility for relief, it will be necessary to consider the democratic judgment reflected in that provision. Nor can Article 8 avail a tenant otherwise than for a very brief period, if he can be appropriately accommodated elsewhere, either publicly or privately. Whereas, noticeably in the case of gypsies, scarcity of land affects many members of the class, and Article 8.2 defence could only, I think, succeed if advanced by a member of the class who had grounds for complaint substantially stronger than members of the class in general. And then he's summarised the practical position. Practical position in future possession proceedings can be briefly summarised as follows. 1, not necessary for a local authority to plead or prove in every case that domestic law complies with Article 8. Court should presume on the assumption that the domestic law strikes a fair balance and is compatible with Article 8. 2, if the court, following its usual procedures, is satisfied that the domestic law requirements for making a possession order have been met, the court should only make an possession order unless the occupier shows that highly exceptional is a seriously arguable case on one of two grounds. The two grounds are A, the law which requires the court to make a possession order despite the occupier's personal circumstances is convention incompatible, and B, having regard to the occupier's personal circumstances, the local authority's exercise of its power to keep a possession order is an unlawful act within the meaning of Section 6. And then the procedural advice is given about the absence of a need for anything more than a short affidavit for the defendant's defence, which can be examined to see whether there is indeed an arguable issue. My Lord, even that approach of the minority may require reconsideration, because Lord Bingham treats P and UR as making it highly surprising, so as being unsurprising, because they demonstrate the ease with which a local authority can rely on an uncontradicted property right. But UR, at least, is subject to a caveat caused by McCann.
So which of the headings in 39 do you criticise?
No, it's not 13. Sorry.
You're criticising the reasoning in 36, are you?
Yes. But I am saying that there is even more need than there was at the time of K to recognise the possibility of a live Article 8 defence. Because, in fact, P, which we didn't go to before the short adjournment, needs to be read in the light of Connors, as Lord Bingham knows because he cites Connors immediately afterwards. But more importantly, UR needs to be read in the light of McCann. The court also has my submissions to the effect that this passage in Lord Bingham's speech and other similar passages should not be construed as providing for an exceptionality test if an exceptionality test is designed to encourage the court to find something exceptional, and should be looking instead for the content of the proportionality test.
But it is striking that Lord Bingham uses the words highly exceptional 5 times in as many paragraphs.
That's true. Paragraph 29, doesn't it?
29?
That's when Lord Bingham, I think, first considers the exceptionality point. And it's quite interesting to see how it develops in that paragraph, and I think that's where he picks it up from. Second half of paragraph 29.
Yes, I hope I've said this already. I don't have a slightest problem with the proposition that it's the last sentence of paragraph 29 that in the overwhelming majority of possession cases, the formulation of a proportionality test will be in no way burdensome, and if someone tries to do it, it can be brushed aside in the vast majority of cases. In a rare and exceptional case, it will not be futile. That may well be an accurate description of the outcome of the exercise, subject to Baroness Hale's point about the frequency with which the joint tenancy situation is going to arise. But it's not the legal test.
It's awkward, though, Mr. Bramble. I mean, if you look at the first sentence of paragraph 38 and put yourself in the position of the county court judge, and then particularly when letter C, just below letter C, they're well used to exercising their judgment and will recognise a highly exceptional case when they see it. And there's a sort of invitation there to the judge to say, well, this is a highly exceptional case, and I can therefore take the appropriate steps. Or he may say, well, it isn't a highly exceptional case, and therefore I can just simply grant the order.
Yes.
I mean, it is difficult to get away from that as the approach that's invited.
I think I accept that, and therefore don't accept that the first two sentences of paragraph 38 give complete and adequate guidance. Because, as I've tried to say this morning, what matters is identification of the factors that are likely to weigh heavily in the proportionality balance. Not enough just to say, my personal circumstances are highly exceptional because of medical condition X, Y, or Z. If it's plain that you've always occupied on limited property right terms, those terms entitle the local authority to possession, there are medical social services available in the community, then the county court, ought to be encouraged to say that sort of issue will not give rise to proportionality defence, not because it's exceptional or not exceptional, but because of the weight to be attached to the various factors in the balance.
Surely all he's saying in paragraph 38 is because in practice it will be unusual, accepting your point that it's all a question of looking at the facts of the individual case, because in practice it will only be an unusual case, it won't be difficult for experienced judges to spot them.
Yes.
That's all he's saying.
I accept that. But what they will be spotting...
May sound maybe easier to say than to achieve, I accept, but I mean, that's what he's saying.
I also accept that.
Well, one of the problems in this case, as you started by pointing out, was that on any view that one took of the proportionality exercise, neither of these cases was going to win.
No.
And so there is no in-depth analysis of how it might be applicable. There's a distinction drawn between cases where the scheme itself doesn't strike the right balance, and we all took the same view of that. And then there was the problem about what about the individual cases where the decision-making allegedly doesn't strike the right balance. But there isn't a lot of analysis of what are the legitimate aims, what are the factors that could counter those legitimate aims, and so on. And it's not surprising in this case.
No.
We are now on to a case where we do have that.
Yes, I respectfully agree with all of that. I mean, just taking it in reverse order, this case enables one to say that the legitimate aim is being pursued by the review panel in upholding the decision to end the demoted tenancy is the protection of the rights of others, the principal others being the neighbouring occupants, Mr. Pinnock having been resident on the estate for 24 years or whatever, and having been originally the beneficiary of an allocation decision, one would expect the eviction only to be legitimate in Section 6 terms if the legitimate aim of protecting the rights of others, namely his neighbours, justified the eviction, bearing in mind there's already been a demotion order. So that's right. Secondly, I also agree that on the facts of K, there was never a need to engage with what might fulfil the requirements of a proportionality exercise. That does
one wonders why. 11 judges and 10 counsel in K took the matter to the House of Lords. I mean, does that throw any light on the likelihood of these cases causing problems, even if they're actually straightforward on the facts? Perhaps it went on the law.
The remedy for that is for the courts, possibly not in a single case, but in a short series of cases, to give a very firm indication of what is or isn't going to wash in proportionality terms.
Of what?
What is or isn't going to wash in proportionality terms, is what I said.
Well, I mean, in Norris, another Article 8 case in a different context, I mean, I think we did actually try and spell out the sort of situations, highly exceptional situations, in which just possibly an Article 8 defence for extradition might wash. But you're contemplating we would do the same thing here.
Yeah.
What's he suggest then?
With respect,
What does he
if Lord Bingham meant that the mental exercise that the county court judge was going to be invited to engage in is this case highly exceptional, without more, then in my submission that can't be the answer. It probably isn't what Lord Bingham meant, as Lord Newberger has pointed out. It's simply predictive of what a correct approach to proportionality is actually going to produce.
At the moment, I'm inclined to feel like Lady Hale, by all means, say it wasn't attempting to give guidance. It was a prediction. I'm just wondering whether it was a correct prediction, really.
Well, McCann may demonstrate that it's an incorrect prediction, but for perfectly acceptable reasons. That is, there is an underlying problem in the joint tenancy cases, because the effect of allowing the common law right of the wife to serve the notice, if it is that way round, or the partner to serve the notice, is to terminate the rights of somebody who has been the beneficiary of a favourable allocation decision and will have been there for some, or may well have been there.
Yeah, I think we all understand that.
Yes. I respectfully, I think, agree with your lordship that it may not be an accurate prediction if you take into account the joint tenancy cases, but whether it's accurate or not accurate doesn't throw any, in my respect, any light on the question which arises in this case, which is a proportionality defence available in respect of the decision of the review panel, which is the short answer, the short question that needs to be answered here. And it's become complicated and difficult because of this line of cases. Otherwise, as I've submitted this morning, one would simply say, well, the review panel is a public authority, it must act compatibly with Article 8, and if it doesn't, it will breach Section 6. What are the factors that feed into its decision on proportionality?
You start with the question, what is the justification for the particular statutory scheme? What is the object of the exercise? Is that an important exercise which really justifies the statutory scheme? If the answer to that is yes, then it's quite difficult to envisage what individual circumstance is going to outweigh that.
Yes.
But if you start with a statutory scheme like this one, which is calling for balancing, or a statutory scheme which has a situation where joint tenancy can produce results which don't necessarily seem to have an underlying justification, then what you weigh in the scales, or what may tip the scales, may be something that goes into the scales much more often.
Yes, and that is relevant to the individual decision.
Yes.
To repeat, if you look at the decisions of the review panel, no one doubts that they are reviewable, subject to issues about forum, is it county court or is it admin court, but they are reviewable for breach of conventional public law errors. Why, one asks rhetorically, should they not be reviewable for breach of Section 6.1? And you will only be able to make up your mind about whether there's a breach of Section 6.1 by considering the individual circumstances of the case, because that's what this part of this statutory scheme is about.
Does Lord Bingham's paragraph 39, head 3A, meet the McCann type of situation?
One thing that I'm not clear about, because I wasn't there in K, is the extent to which the argument in K focused on the court's role as a public authority under Section 6, or focused on the local authority's role as a public authority in seeking possession in the first place. If you see it through my eyes, that the critical question is, has the public authority, i.e. the housing authority, acted in breach of Section 6? The contrast between gateways A and B, whether it was formulated by Lord Bingham or was formulated by yourself,
Yes.
rather disappears.
Yes.
Because if you have a scheme which allows but does not require a convention non-compliant decision, the public authority, i.e. the local authority, will always have to make a convention-compliant decision, and there will be no distinction between A and B. It's only if instead you're looking at the position as the role of the court, then there may be a real difference between A and B, because on A, the court will be required to decide the matter in accordance with the scheme.
Now, when you're referring to A and B, you're referring to the notorious paragraph 110.
Yes, but there's an echo of it in 39.
There is, yes.
Yes, I am indeed. Can I just, I was going to take your lordships and the lady to this in a moment, but keep on going on about Lord Brown's passage. But can I have the passage in Lord Brown's speech? Can I just take your lordship and my lady to it? Because it's the source of my confusion about what was truly happening in K. If the court will go to paragraph 207, my Lord Brown said, I too therefore would dismiss both these appeals, but I would do so for a reason more fundamental than that suggested by certain others of your lordships. These appellant's defences must fail, not because they disclose no sufficient highly exceptional personal merit, but because they depend upon establishing a freestanding Article 8 right to remain in possession incompatible with the respective claimant's clear entitlement to possession under domestic property law. I would hold that no freestanding right exists. Now, possibly surprisingly, I have no problem with that passage, because what Lord Brown goes on to say, I should perhaps add this. These appeals were brought on the basis for the trial judge, pursuant to his Section 6 duty, to consider for himself the issue of justification under Article 8.2 in any contested possession action. There is, however, a quite different basis upon which an occupier could challenge a public authority's claim for possession, namely on the conventional public law ground that the decision to bring a claim was itself so unreasonable as to be unlawful. Such a defence could be advanced in the county court, see Wandsworth and Winder. The difficulty with such a defence, however, is it would be well nigh impossible to make good, the challenge necessarily postulating that under domestic property law the claimant was entitled to possession. Accordingly, the argument could only be that no reasonable public authority could properly invoke that domestic law right. This would be a more stringent test that would apply where the court, as the appellants assert, under a primary duty to reach its own judgment on the justifiability of making a possession order. For my part, I think that such an argument could perhaps have been mounted successfully in Connors, having regard to the great length of time, most of the preceding 16 years, that that gypsy family had resided on the site. It was unreasonable and indeed grossly unfair for the local authority to claim possession merely on the basis of a determined licence without the need to make good any underlying reason for taking such precipitate action. That was not, be it noted, the basis of the actual judicial review application for which permission was sought, in that case was sought and refused. And then there's a comment about how the application for possession only followed in time the dismissal of the judicial review action. It's difficult to suppose, however, that a defence based on a public law challenge of this character to a public authority's decision to pursue its domestic law rights could properly succeed, except in such an infinitely rare case as in Connors. Manifestly, it would not have succeeded in either of the present cases. Strauss explains why defences of this particular character were not advanced. Now, there Lord Brown appears to be envisaging that the argument that was being advanced on Mr. Kay, on behalf of Mr. Kay and Mr. Price, was the horizontal direct effect argument. The court itself is a public authority and therefore must act to protect the convention's rights.
But what I didn't envisage, and I think you would say should have been envisaged, was actually not a Wednesbury type challenge brought, of course, in the county court pursuant to Winder, but rather a simple challenge on the basis that the public authority's decision to proceed was itself offensive to the proportionality requirement under Article 8, and that under 7.1b of the Act, I mean, that was something that could perfectly well have been decided.
Yes.
I mean, which is an easier road to success than we were contemplating there.
Well, that in a way is my whole case. Yes, absolutely. If you marry your Lordship's passage in 208 to 211 together with the realisation that a defence can be based upon a breach of Section 6.1, as well as conventional judicial review grounds, one has an answer. It has an easy answer on the facts of this case, depending on what you make of the proportionality argument. But the proposition that the review panel cannot be reviewed on for breach of Section 6.1 seems to me unsustainable. If it can be reviewed for breach of Section 6.1, then prima facie it can be reviewed and the defence can be taken in the county court. Section 7 is a particular quirk about this statutory scheme, which we're going to need to address, but subject to that analysis is straightforward.
I think the problem which we were envisaging is picked up by Lord Brown in 203, isn't it? I mean, he's envisaging, on the one hand, a situation where domestic law requires the court to make a judgment or exercise a discretion, and in those situations the judge will bear in mind that he's performing a task in the context of Article 8. That's one thing. But the real problem is where under domestic law the right to possession is plainly made out. And then you have to assume, well, domestic law has struck the Article 8 balance, and then what is left is the problem. And that really is the critical thing that was troubling the majority.
I don't need to have a problem with that if the public authority that is being considered and is therefore driven to a particular conclusion is the court.
Yes.
I mean, if you envisage a situation as being one in which the local authority has served the requisite notice and taken possession proceedings, that is a given when you get to the stage of the court. Then, subject to very complicated arguments about horizontal direct effect, which I don't want to get into, that is indeed the end of the story. The court is compelled by the terms of the relevant legislation to make the order. But that misses the point that the decision of the local authority to serve the notice can be rendered unlawful either as a matter of pre-Human Rights Act public law, or because it's disproportionate and therefore a breach of Section 6.1. And that seems to, certainly in the argument as recounted by Lord Brown, to have fallen out of the debate.
I mean, at the time of Kay, the majority of us were supposing that except in a case like Connors, where you could actually attack the legislative scheme itself as being intrinsically non-compliant. I mean, as I think we pointed out there, paragraph 199, I was saying, the domestic law under which possession was sought in order couldn't be justified. Only gypsies, indeed only gypsies, living on local authority caravan sites were excluded from the protection. So there was defective legislation. But otherwise, unless the legislation was defective, we said, and under the Strasbourg jurisprudence as then it was understood, if there was no security offered under domestic law, that was because that was regarded as the acceptable balance, and that encompassed and subsumed considerations of proportionality no less than legitimate aim. Now you say, Strasbourg has moved on, see McCann, and actually that's just not, doesn't answer the question.
Is that not ground? I'm looking at paragraph 110 again. That's Gateway B, as formulated there, which is making all the assumptions that Lord Brown has just mentioned. But it's leaving still open the possibility that the defendant wishes to challenge the decision.
Or is this
110 Gateway B on page 517, just above D. So the gateway leaves open the possibility of a challenge, even in that situation.
Yes.
On the common law grounds.
But only on common law
Yes.
grounds. Now,
And I say the same in paragraph 190.
yes, that with respect.
Yes. That's where we come together.
Quite so often, is a mistake that is an overhang of the false starting Kazi. I say false for the benefit of hindsight because of the later decision. Because the analysis of Kazi, or the majority, was to the effect that the legislative scheme would always provide the answer to the 8-2 balance. The moment you realise that's not the case, and that the majority were wrong, as is now accepted to say it was the case for the benefit of hindsight, then it becomes possible for the public authority, not the court, but for the originating public authority, if I can say that, to breach Section 6.1 by making an individually disproportionate decision.
Because the public law authority has a public law duty to that it has to discharge in deciding whether to exercise its legal rights.
But some of those cases would be caught by Gateway A, wouldn't they? Because, I mean, that's assuming that you can attack the legislation under which the public authority is acting and saying, well, it doesn't give it the opportunity to take the kind of decision you're talking about. And if that is a defect in the legislation, it's because it renders it incompatible with Article 8, and therefore it could be challenged in the way that Gateway A mentions.
This is where one gets into Section 6.2b, because you only need Gateway A if the incompatible legislation requires the non-convention compliant decision of the housing authority in order to give effect to the statutory scheme, to use the language of 6.2b. If it doesn't, and the local authority is free, having regard to the case law in 6.2b, to make a different decision, then if it continues to make the convention non-compliant decision, then that will be a defence in the county court.
Well, little
subject
one
to quirks of the
in Gateway.
individual scheme. But
Sorry, go on and cross-examine you about this,
No,
but
no,
this little one of Gateway A does allow for that, because it's assuming you can actually construe the measure in a way it's possible to do so, in a way that's compatible with Article 8. And if it is, then you do that, and you give effect to the provision in that way.
Yeah, I of course accept that under Gateway A, if you have what appears on the face of it to be convention non-compliant legislation, then the interpretive duty under Section 3 may enable the court or require the court to avoid that conclusion. That I accept. But if the result of the apparently convention non-compliant legislation, either interpreted straightforwardly or with the benefit of Section 3, leaves the authority free to make a decision which is convention compliant, then 6.2b will not, in my submission, come into play. We need to go to precisely what 6.2b requires in a moment. And therefore there will be a defence in either judicial review proceedings or the county court, even though the legislation remains non-compliant in the sense that it contemplates decisions which are convention non-compliant. I hope that makes sense.
Well, I mean, I don't know why you need bother with it in context of public authority, is whether the legislation is or isn't convention compliant, provided only that it doesn't actually force the authority to claim possession. It's all there anyway. I mean, you just simply say to invoke this legislation here to dispossess, to evict, would be a violation.
Yes, I agree. I mean, that's why I said 10 minutes ago that the effect of this line of argument is to erode the distinction between, or remove the need for the distinction between gateways A or B at all in individual decisions.
I suppose the importance of the distinction really is that, of course, if it's basically compliant, I mean, if it's fundamentally sound and it is to achieve a legitimate aim, then it's much, much harder to say that it's disproportionate.
I would accept that.
Yeah.
It goes a bit further than forcing the authority to do something. If the authority has an option, which if it exercises it will necessarily violate the convention, then again the authority will be entitled to exercise that option.
Well, that's the debate about 6.2b.
Yes.
And it depends what you mean by having an option, as I understand it. If the scheme plainly, I'm jumping ahead to an important point of the argument on Doherty, but if the scheme contemplates and envisages that as a matter of routine, the local authority will make an option, follow an option which produces a breach, even but there is a remote possibility of avoiding it, then it may well be that the carrying out of the option which creates the breach is giving effect to the statutory scheme. But short of that, it isn't. I mean, if you take Connors, for example, the local authority has the option of either terminating Mr. Connors' tenancy, license agreement, whatever it was, or not terminating it, to terminate it in circumstances where you give no reasons and do it in a form where the court can't adjudicate on whether or not the original nuisance took place, does create a breach. The local authority is not obliged to do it that way. Then in my submission, the local authority is not protected by section 6.2b. The example at the other end of the spectrum is Hooper, where the statutory social security scheme provided for payments to widows but not to widowers. The government had, in fact, dealt with some successful Strasbourg cases by making ex gratia payments to widowers, they having won in Strasbourg. So the argument went, well, you can avoid the breach of the convention by making a whole series of ex gratia payments to everybody. The Lords, in slightly different sets of reasoning, held that that was to subvert the statutory scheme, and therefore the central government would have a defence based on 6.2b for failing to make the ex gratia payments. But that's not this case. It's not either Connors.
I'm sorry to interrupt, but personally I'm inclined to think that 6.2b is the most difficult point in this case. And I don't know if this is just general softening up for something that's coming later, but I do find it difficult to go to the most difficult point in the case without actually having looked at 6.2b. I'm not inviting you to do it now, but at some stage we will do that, will we?
My Lord, I certainly intend to spend some little time on those parts of the judgments in Doherty and indeed in Hooper which deal with 6.2b, and therefore necessarily to be looking at the language of 6.2b. And I'm of course familiar with what your Lordship said in Doherty about
I need to be reminded of it, but I do think at some stage we're going to have to look very carefully at the text of section 6.
Yes. Well,
in your own good time.
That I accept, and that's precisely next on the. No, it isn't quite next on the agenda. Actually, it has to be on the agenda. Can I just deal with the remainder of K shortly, because I probably made my basic submission on it. Lord Nichols was part, again, of the minority. Typical paragraph in Lord Nichols is paragraph 59 page 501. Where he says the human rights challenge may take a different form. The local authority is obliged by Section 6 to act compatibly with convention rights. The defendant's contention may be that the local authority's exercise of its power to seek a possession order is in the circumstances an unlawful act within the meaning of Section 6. As with the challenge to the convention compatibility of housing legislation, so here it will be a rare case indeed where this allegation can be made good. This is because in the ordinary course, a public authority in seeking possession will be doing no more than relying on its ownership of land, coupled with the limits on the defendant's rights of occupation as determined by Parliament, or where the defendant never had any rights of occupation, coupled with his absence of any rights to be present on the land at all. However, if a convention compatibility issue under Section 6 is raised in county court possession proceedings, the court is the appropriate forum for deciding, that court is the appropriate forum for deciding the issue. It's the appropriate forum because in such a case the defendant is entitled to rely upon this allocation as defence in the possession proceedings, Section 7(1)b of the Human Rights Act 1998. If the allegation is made good, the court may grant relief as provided in Section 8 of the Act. The relief would include dismissing the possession proceedings or staying a possession order for such period and on such terms as the court considers just and appropriate. Therefore, agree with the practical position as set out in paragraph 39 of the speech of Lord Bingham. That's our analysis, we respectfully adopt that analysis as being the correct approach.
Paragraph 60 is Gateway B, I think, isn't it?
Yes, yes it is.
Yes. Yes, indeed. I think the argument I'm advancing today is that Lord Nichols was entirely right to see the two as alternatives, two alternative attacks that could be made on the originating decision of the local authority in the county court. And that is what one would expect. It's a matter of general approach to public law. Almost all public law decisions in the convention against the background of a convention will allege some sort of domestic public law breach as well as a breach of proportionality. And so Lord Nichols is entirely right to be seeing the two together. He said. Lord Walker was the third member of the minority. Your Lordship and my lady will find his short speech at page 534. And the most important part for present purposes is probably 176. So your Lordship can read it.
Yes.
Your Lordship knows my
Yes.
approach to it. Now, otherwise,
Speaking for myself, I did find that earlier draft extremely helpful in illuminating exactly what things
the
would...
problem.
Yes,
Well, I haven't seen it.
of course not. But I wish to pay it tribute.
Does it exist?
Yeah. Well, your Lordship, you and the lady have gathered that I accept that the sensible course is not to try to guess in advance every possible combination of circumstances that might give rise to a proportionality defence. Possibly at the most to say the sort of factors that are going to weigh heavily in the assessment of proportionality. Well, the other part and crucial part of K is paragraph 110 in Lord Hope's speech.
I think Mr. Drabble will embark on that tomorrow morning.
I wasn't going to spend a long time.